Hello, everyone. I would like to welcome everyone to today's Lawyers for Learners webinar, Tribal Law in Wisconsin. My name is Eileen, and I'm a student paralegal intern with Legal Action this semester. Thank you for joining us today. We are honored to have Douglas Twait here with us today. Douglas Twait is the director of the Indian Law Office with Judicare Legal Aid. Thank you for being here with us today and sharing your expertise. With that, I will turn it over to Doug.
Thank you so very, very much. At Judicare, we try to be very, very supportive of the tribal court systems here in the state of Wisconsin. We have 11 federally recognized tribes in the state. Each of them run their own court systems. And we participate very much with there's an organization called the Wisconsin Tribal Judges Association and the Wisconsin Tribal Court Clerks Association. These two organizations meet very, very regularly, and they work real hard to support one another and complement one another and continuously help one another improve the capacity of their court systems. They work very, very hard and diligent. They do a fantastic job, and Judicare tries to be as supportive of them as they possibly can. I'll just make a brief introductory note about Judicare Legal Aid and who we are. We have been in existence since about 1966. We serve low-income residents in civil law matters in the state of Wisconsin. Our office serves the northern 33 counties in the state of Wisconsin, but we do represent Native American members and tribes statewide. I have to say, I've been in this position of Indian Law Office Director for a very short period of time. But everywhere that I've gone across the state, meeting people on reservations and in meetings and whatnot, I've got nothing but the warmest of receptions. And that tells me that that's because of the absolute fantastic reputation that the Judicare has earned over the years since 1966 of the service that they've provided. And thanks, this slide that we're looking at now, I hope gives a pretty good visual of geographically where the 11 federally recognized tribes are in the state of Wisconsin. I think it's a pretty good graphic to see that. And it's very much my intention in this presentation that instead of me just reading from a PowerPoint presentation, that we create a dialogue, and we have a dialogue, and that can be very meaningful to the participants involved. That you're going to have access to the PowerPoint and a whole bunch of other materials that we've submitted ahead of time that I think are very, very important. And it's not at all imperative that I get through the PowerPoint, and I'm actually kind of hoping that I don't, because I think it would be much more valuable to the participants if we engage in a dialogue as opposed to, like I said, me just reading through a PowerPoint presentation. One of the things I want to especially draw your attention to among the materials provided, there's an excellent piece by Samantha B. In the show that she's been doing. You may or may not be familiar with it, but one of the things I think she does is by using wit and humor. She does an excellent job of, I think, kind of dispelling some of the myths about tribal courts. So I would really encourage people to take a look at that. I think that in addition to being amused and humored, it really does a pretty good job of stripping away some of the myths that you might think about going into Troy and practicing in tribal courts. And you have to be respectful of the fact that that you are in a different sovereign. You're in the court of an entirely different sovereign than the state that you happen to be in. But at the same time, it's not as though you've been sucked into some kind of a wormhole and you've been pulled into some kind of a weird, esoteric and exotic place that's quite unlike anything you've ever seen before in your life. It's not that kind of an experience at all. But you have to be mindful and respectful of the fact that you are in a different sovereign. Could I have the next slide, please? Thanks. And again, one of the main things in interacting and in dealing with tribal courts is to recognize that that they do represent separate and distinct sovereigns from the state that you happen to be trying in. And they have their own laws and rules and sets and things like that. Now, the rules and law may be quite similar to, in many cases, the law of the state that you happen to be in. But like any jurisdiction, if you want to be a good lawyer, you have to be very conversant in the laws and regulations of that particular sovereign. So I would encourage people to do that as you have your experience in tribal courts. Next slide, please. One of the things that there is particularly here in the state of Wisconsin that is particularly impressive is the interaction between state court systems and tribal court systems. Through much of my career, I've had a lot of experience in different states and localities, particularly in the state of Minnesota. And I have to say, Wisconsin is far ahead of other states, particularly Minnesota, when it comes to interaction between tribal courts and state court systems. And that, I think, is a tribute both to participants on the state side and the tribal side in terms of putting in a lot of long and hard work, working together and working out very cooperative systems. One such cooperative system that you can see there's the Teague Protocol, and that comes from a state Supreme Court decision in the year 2000, I believe it was, whereby if there's an issue where either a tribal court or a state court arguably has jurisdiction over the same matter, that there be some mechanism to sort out where that matter should go for resolution. And the Teague Protocol actually is a written document that's been generated. The Teague Protocol itself is only applicable in the 9th Judicial District in the state of Wisconsin, but the Supreme Court precedent, Teague, is applicable statewide, and it does provide an excellent mechanism for working out instances where there is arguably jurisdiction between a tribal court and a state court for resolving where is the best place for that particular matter to be heard. And once again, that's a tribute to people working on the tribal side and the state side over the course of years to make something like that really work. Something like that doesn't come automatically. People have to put in a good long amount of hard work to make something like that work. What's not on your slide, there's a state Supreme Court rule 80154, for those of you scoring at home, that interacts for when it's appropriate to transfer a matter from a state court to a tribal court. And this rule has been enacted over a long period of time, much interaction between the state courts and the federal courts, many hearings. And while it has not been without controversy, because there has been some dissent among the Supreme Court among this matter, the rule has recently been made permanent, and it does provide a very nice mechanism to provide when a case can be moved from a state court to a tribal court. And that's a very valuable thing. And in the whole entirety of the United States, this is a huge breakthrough that the folks here in Wisconsin have been able to accomplish. Next slide, please, if we could. And again, I mean, these are just two examples of statutes that talk about why we have tribal courts, but they're just two examples. And I guess the main thing is running a tribal dispute resolution system is a fundamental aspect of tribal sovereignty. And that's why tribes have courts, and that's why they'll continue to have these courts, and their courts will continue to improve. Next slide, please, if we could. Public Law 280, and I'll just, before I talk specifically about Public Law 280, one of the interesting elements about the history of federal Indian policy in the United States is just over the course of time, it's been wildly different and deviant from time to time, and things with different goals and different outcomes. And at various times, it's meant to support tribal sovereignty and enhance tribal sovereignty. And at other times in history, it's meant to just outright terminate tribal sovereignty and eradicate Indian tribes altogether. And anytime you have a backdrop of a history that is so wildly fluctuating, you're going to have difficulties and problems. And people talk about there being historic trauma and that sort of thing, and there really is. If you don't, from the history of the country to today's date, if you have such a wildly fluctuating policy, you're going to have difficulties. But through resiliency, people are able to continue to work through that, and they do to that day. And Public Law 280 is one example of that, and that's a situation where in an area, previous era called the termination era, where it was an overreach by the federal government that allowed certain state governments to assume criminal jurisdiction in Indian country, and Wisconsin is one of those places. You'll see that the Menominee Reservation is an exception to that because they've had their own traumatic history with regard to this in terms of being terminated at one point and then being restored at another point, mostly through the absolute courage and resiliency of that particular tribe, Menominee. And through their restoration, when they came to be restored, they were not under the burden of Public Law 280, and that particular tribe does exercise criminal jurisdiction. And next slide, please. And once again, if there are any questions or comments or any dialogue that people want to have throughout this, please feel free to ask the question. And like I said, I think dialogue is a much better way of would be much more meaningful to the participants than, like I said, me just merely reading from a PowerPoint registration. Let's start with the Menominee tribe and look at their court system first. If we can go to the next slide. What we've tried to do through this presentation is not to answer all your questions, but to give you access to where you can find resources about the particular tribes and their particular court systems. And these are fairly consistent throughout of all the 11 federally recognized tribes in the state of Wisconsin. And we'll start with the admission requirements to be a member of the bar, the Menominee Judiciary. You have to be a member of good standing in a state court, and you have to pay a $25 fee. It's not any more complicated than that. And you can see from the remainder of the slide where you can find different sources of information concerning the Menominee tribe and their sources of law and where you can find that. Next slide, please, if we could. And again, you can see there that they practice general subject matter jurisdiction. And if we could go to the next. And like I said, the Menominee is one of the few that in Wisconsin that actually does maintain, they're separate and distinct from Public Law 280. So there is criminal jurisdiction in the court system. We at Judicare are very proud to play a big role in terms of working with the Menominee tribe, and we do a lot of defense work and for adults in their criminal court and for their juveniles in their juvenile court system. And that's been a great relationship between the Wisconsin Judicare and the Menominee tribe, which is greatly, greatly valued by us here at Judicare. Next slide, please, if we could. And again, there's just some more information about territorial jurisdiction and personal jurisdiction of Menominee. And again, the next slide. There we go. We move on to now we can look at the Ho-Chunk tribal court systems. Next slide, if we could. Thank you. And you can see their admission requirements for the bar. They do have a bar exam that you have to take that focuses particularly on ethics questions. Not to be too intimidated by it. Bar exams can be very intimidated, but you shouldn't be. And if people are lawyers, we encourage our lawyers seek membership in the bars of the various tribal court systems, even notwithstanding if you have to take a bar exam, that shouldn't be an insurmountable burden, and we encourage people to do that. And you can see some other information here about the Ho-Chunk Judiciary. And if we could have the next slide, please. And what we try to do is we try to outline some of the sources of power and authority for that particular judicial system. Next slide. And again, we continue with some of that. And we hope that some of these links are helpful for people who have particular interest in particular tribal court jurisdictions in terms of providing more information where you can get more information. And next, if we could. Forest County Potawatomi, another tribal court system in the state of Wisconsin. They also do have a bar exam for admission, and the same things I had to say previously about not to be intimidated by a bar exam as a means of practicing in that tribal court. You can see also the kinds of subject matter jurisdiction that they practice and the kinds of issues that come up in that particular tribal court system. Next slide, please, if we could. Thank you. Stockbridge-Muncie Tribal Court System. Their admission requirements: 18 or older, admitted to a state bar in good standing, no felonies. You take an oath and $100 annual fee. No bar exam there, so to the extent that might have been an intimidating factor, you don't have to worry about that at Stockbridge-Muncie. And then, next slide is fine. Thank you. And you can see the sources of some of their laws, or constitution and bylaws in their tribal ordinances. One thing that the Tribal Judges and Court Clerks Association are continuously trying to do is find ways to make court law and even now court decisions more accessible so that people can have access to them. And to the extent to which people can have easily, readily available access to tribal law and tribal decisions, that helps dispel some of the what might be myths about tribal court systems here in the state of Wisconsin. And then the next slide, if we could. And there's more about Stockbridge-Muncie Tribal Court System there. A lot of tribal courts have been very, very pioneering in terms of, typically we think of a judicial system as adversary, in that, two parties clash against one another and one wins and one loses. And there's some value to a system like that, but a lot of tribes are experimenting with alternative methods of, peacekeeping and healing the wellness and other ways of doing it where you don't just have to have an adverse confrontation with a winner and loser, where people can engage in more dialogue and mediation and find a solution that is more holistically beneficial to everybody involved. And tribal courts in particular have been real pioneers at trying to find culturally based way to get outcomes of this nature. And it's excellent to see those kind of outcomes and efforts continue. And next, if we could. And again, you can see some of the subject matter that the Stockbridge-Muncie exercises jurisdiction over in their particular tribal court system. And next. Thanks. We move on to Oneida. And again, their requirements to be a member of their bar are, they have an admissions practice form and a certificate of good standing from the state, criminal background check, and a $100 fee. And they also have similar, many courts also, in addition to lawyer admission to their bar, they also admit lay advocates to the bar as well. And that the more people that participate in any given court system, I think, is better for the court system and for the participants. And for those of you in the audience today who are not lawyers, that doesn't preclude you from applying to be a lay advocate. in many of our Wisconsin tribal courts, and we'd encourage people to think about doing things along those lines. Next, if we could, please. And again, we sort some of the sources of power for the Oneida judiciary, and we list some of the areas of jurisdiction that they entertain within the court, and you can see all kinds of things get heard in that particular tribal court as well. And next, if we could. And again, there's another example of looking at alternative to just the pure adversarial way that a judicial system works in terms of utilizing peacemaking and other kinds of mediation situations to find a resolution that can be more mutually beneficial to everybody. At the end of the day, restorative justice sort of means that let's try to restore ourselves to the point in time before the bad thing that we're trying to resolve happen. And like I said, the Oneida and many court systems are trying to develop alternative dispute resolution mechanisms that can arrive at those kinds of more holistic and overall beneficial results. And those ongoing efforts are to be applauded and absolutely encouraged. And next, if we could, like the Flambeau tribal court system. There's admission to the bar requires only an attorney certificate of good standing and a fee of $75. And they also have lay advocate possibilities. And for those of you who have expressed interest, once again, I would highly encourage both the lawyers participating in today's event and non-lawyers who have interest in lay advocacy to very, very carefully consider application to be member of the bars of these various court systems, because that could be beneficial for you, and it helps to build capacity of the particular court systems, the more participants that they do have. Next slide, please. And again, you can see, jurisdictional subject matter jurisdiction and personal jurisdiction of the Lac de Flambeau judiciary. Next slide. Coup de Ré tribal court system. Next, please. And their admission requirements are $100 fee for attorneys, $50 for the lay advocates, and complete the court admission form. And we, once again, would encourage that. And you can see there, we're trying to provide links to the various sources of power for the court system, the resolution ordinances, constitution, and bylaws that govern practice in the Coup de Ré tribal court system. Next, please. And you can see the various jurisdictions, both subject matter and personal, that they practice in that particular judiciary. And I hope as we go through this, you're getting the impression that these court systems here of the tribes in Wisconsin are very, very active and robust, and very good tribal court systems. Next, please. Bad River. And again, theirs is just a bar exam and a $25 fee. Recently, the Bad River put on a very nice workshop for those desiring to take the bar exam that was very, very helpful. And so once again, if people have an aversion to taking a bar exam, please don't let that be in any way detrimental to your consideration, especially at Bad River, because they bend over backwards to facilitate people's comfort in participating in their judiciary. Next, please. Okay, and again, you can see the various types of subject matter and personal jurisdiction practice at Bad River. And again, next, St. Croix. St. Croix, $25 admission fee. That's for the admission to that particular bar. Judicare has a nice relationship with the St. Croix court. We have a contract with them to provide guardian ad litem work, and we work very, very closely with that particular judiciary. And we love doing the work, and we hope that we're providing a good service to their court system and performing that type of work. Next, please.
Doug, we have a question.
Oh, great.
So, regarding the pending Brackeen decision, even though Wisconsin has codified the ICWA, are there concerns that there will be similar challenges to the WICWA should SCOTUS find ICWA unconstitutional on equal protection grounds?
That's a very interesting question, a very, very pertinent question. There have been actually the Brackeen decision, for those of you who might not be immediately familiar, is a very, very important Supreme Court case. Recently had oral arguments. We're anticipating this decision in late spring to summer. And the consequences could be anywhere from minimal to devastating. People have tried very hard to read the tea leaves of the oral arguments in that particular case. You really can't. You have to cross your fingers and kind of hope for the best. But you're right. Wisconsin has passed a statute, their own version of the Indian Child Welfare Act. The two main challenges to the Indian Child Welfare Act and Brackeen are, as the questioner noted, the equal protection, which if they rule that up until now, the classification of being Indian has been considered a political classification, not a racial classification, and therefore a permissible designation. One of the things the challengers to the Indian Child Welfare Act are asking the Supreme Court to do is to find that it's not a political distinction, and it is a racial distinction, and then hence an impermissible racial distinction under the Equal Protection Clause. A second challenge to the Indian Child Welfare Act is the opponents are saying that it violates the anti-commandeering section, which means that the federal government cannot commandeer state court mechanisms to perform federal functions. And the astute author of this particular question, if the Supreme Court finds it violates equal protection in that the designation Indian is deemed racial and therefore impermissible, that probably means that the Wisconsin state statute would also be vulnerable to a similar kind of attack. If, however, the Supreme Court would decide that it violates the anti-commandeering provisions, meaning that the federal government cannot commandeer a state mechanism to perform a federal function, under that situation, I think we would be in good shape still with regard to our statutory scheme here in the state of Wisconsin. But we've all got our fingers crossed with this particular one, because at its worst, it could devastate the entirety of Indian law in this country. And on the other end, they're hoping the best possible result may be it makes some minor changes in the order of preference for placing Indian children under the Indian Child Welfare Act. It's actually a bit ironic in the sense that one of the main opponents of the Indian Child Welfare Act is the so-called Goldwater Institute, which is kind of a conservative think tank, which is named after the late Senator and presidential candidate Barry Goldwater of Arizona. Interestingly enough, when Senator Barry Goldwater was in the United States Senate, he was one of the key proponents and advocates for the Indian Child Welfare Act. But that was a very, very good question. Everybody's watching that very, 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 very closely. And it's interesting to, one of the very, very breakthrough case that in recent Supreme Court history was the McGirt case, which held that not only in the state of Oklahoma were Indian reservations still intact, but they still retained criminal jurisdiction over much of the state of Oklahoma. And that was a very, very important, compelling Supreme Court decision that expanded the reach of tribal sovereignty and was very, very welcome in a lot of quarters within Indian country. And just a few years later, in this most recent iteration of the Supreme Court, the Carlos Huerta case, was a case that was very destructive of tribal sovereignty, in the sense that years and years and years, the court has not on its own initiative expanded the reach of a state government within Indian country. And prior, they've said Congress has to express such a reach into Indian country. But what they did in the case of Carlos Huerta was, on the court's own ruling, they did. And the difference between the McGirt court and the Carlos Huerta court was a single member of the United States Supreme Court. Ruth Bader Ginsburg unfortunately passed and was replaced by Coney Barrett. And that makes all the difference in the world between a Supreme Court decision that was forcefully in favor of in advancing of tribal sovereignty, and one that was very destructive to it. And that just shows the nature of what we have to face with such a narrowly divided 9-member Supreme Court of the United States Supreme Court. Like I said, the entire presentation is available, and there's a lot of background information that we've also provided. At the end, I've also provided my email address and that of Jordan Winquist, who's a staff attorney here at Wisconsin Judicare. And if anything that we've said during the course of this has sparked any need for further dialogue, or for further discussion, or further questions or concerns, if you would send an email to those one of those both of those addresses, we will do our very best to either continue the dialogue with you or find answers to whatever questions that you might have. And once again, I very much congratulate people for your interest in this subject matter. And I think it's wonderful that people have expressed interest in tribal courts, and that we should be very respectful and supportive of them. And we should be continuing respectful of the efforts by the state of Wisconsin and the tribal courts within the state of Wisconsin to continue their good work of cooperating together. And with that, thank you very much. I appreciate your time and attention today.